Hi, everybody. Welcome back. I'll conclude our discussion of criminal liability by discussing a famous constitutional case decided by the Supreme Court of the United States in 1971 that beautifully illustrates almost everything we've had to say about criminal liability. The case is called Magathas versus California, and it concerns an armed robbery and a murder. Magathas and Wilkinson, both armed with handguns, one day in 1967 entered the convenience store owned by Mr. and Mrs. Benjamin Smetna in Southern California with an intention to rob the store. They did rob the store, and in the course of the robbery, Mr. Smetna was shot and killed. But later at the trial, when Magathas and Wilkinson were tried for the armed robbery and the killing of Mr. Smetna, the evidence was inconclusive as to which of them had fired the fatal shot. Wilkinson said Magathas had fired it, Magathas said that Wilkinson had fired it, and the jury was not given sufficient evidence to determine which of the two individuals had actually fired the fatal shot that killed Mr. Smetna. But under California law, it didn't matter which of them had actually fired the shot, because both of them are equally guilty of the same abstract crime, which in California was first-degree felony murder. A felony murder, as opposed to an ordinary murder, takes place without the individual murderer necessarily intending that the murder be carried out. A felony murder occurs when an individual is in the midst of perpetrating a violent felony and somebody dies. If this happens, then the perpetrator of the violent felony is guilty of first-degree felony murder, whether it was his or her intention that the victim die, or whether the perpetrator did anything directly during the violent felony to cause the death. So, for example, if Mr. Smetna had, in the midst of the robbery, dropped dead from a heart attack, that too would have been a felony murder, and Wilkinson and Magathas would both be equally guilty of it. So, in this case, it doesn't matter which of them fired the fatal shot, because both of them were engaged in perpetrating a violent offense, and because Mr. Smetna died during the commission of that violent offense, both Magathas and Wilkinson, and this is the important point, are guilty of precisely the same crime. In California, there are only two alternative penalties for first-degree felony murder in 1967, and those two penalties are death in the gas chamber or life imprisonment in the California prison system. So, indeed, in this particular case, in California, trials of this sort for serious offenses like this were broken into two parts. In the first part, the guilt or innocence of the defendants is adjudicated. In the first part of the Magathas trial, the jury heard evidence about the armed robbery itself, and Magathas and Wilkinson were found guilty of having committed the armed robbery and found guilty, each of them, of first-degree felony murder on the basis of the evidence presented at trial. Then, once the guilty verdict was returned, the jury is reconvened for a second part of the trial called the penalty phase of the trial, and in the penalty phase of the trial, the defendants are given the chance to plead for their lives. Notice that if there were no such separate penalty procedure, then defendants would be in something of a pickle when it came to pleading for their lives. If the trial had not yet determined that they were guilty, it would be very difficult for them to say, yes, I did the crime, but you shouldn't sentence me to death because there are these mitigating circumstances to it. And so, to avoid putting defendants in that difficult position of not being able to plead for their lives while their guilt or innocence is still being adjudicated, California split capital cases of this sort into a two-part or two-tiered trial procedure, the first part determining guilt or innocence, and once guilt was determined, the second part determining the actual sentence. And so the jury was reconvened to hear evidence about Magatha and to hear evidence about Wilkinson so that the jury could determine what the sentence to be imposed upon each of them would be. The key feature of the case is that this sentencing decision was committed to a jury, but neither the state of California, in its statutory law, nor the trial judge who instructed the jury as to how they were to sentence in this case, neither the law nor the jury, the law nor the judge gave the sentencing jury any specific guidelines or instructions about how to determine the sentence. There was nothing in the law that suggested how the legislature thought first-degree felony murderers who should die should be distinguished from first-degree felony murderers who should not die, and the trial judge offered no advice either in this direction, and so the jury was left entirely on its own, without any assistance from the law or the judge, to determine the moral costs of the two crimes and to impose the appropriate sentences. The only instruction that they were given was that they were to act without prejudice, whatever that might mean. And so, at the penalty trial, Magatha and Wilkinson, through their attorneys, literally pleaded for their lives. It was revealed at the penalty phase of the trial that Magatha was older than Wilkinson. I guess people could have seen that at the trial itself. That he had come from a broken home with some violence in it. That he was a veteran of World War II and had been honorably discharged. He had 4 prior violent felony convictions, although he tried to talk his way out of the seriousness of those convictions, and he was able to present no witnesses to testify about his character. Wilkinson, on the other hand, was shown at the penalty phase of the trial to be much younger than Magatha, to be a person of rather low intelligence, but a person who had been a generally good citizen until he himself had been the victim of a crime, and as a result of the injuries that he'd received as the victim of a crime, he was unable to work thereafter. His life spiraled downward, and although he had no prior criminal record at all, he fell in with a bad crowd, including Magatha, was taken along on Magatha's spree of armed robbing on the fatal day, and found himself in the same situation that Magatha did. And so both of these individuals asked the jury to spare them. The jury deliberated, trying to determine the appropriate penalty, and when they came back with the penalties, Magatha was sentenced to death in the California gas chamber, and Wilkinson was sentenced to life at San Quentin Prison. How can we interpret this? Well, it's relatively straightforward in terms of what we've been saying. The jury reckoned the moral costs imposed by Wilkinson's felony murder to be smaller than the moral costs that were imposed by Magatha's felony murder. That is, as we've seen, the two criminal entitlements, the ones that Magatha took and the ones that Wilkinson took, were not the same good. They were not homogeneous. And as a result of this, as a result of the smaller moral costs associated with Wilkinson's crime, Wilkinson's compensatory liability price was smaller than that inflicted upon Magatha. And because the jury was given no guidance or standards by the law or the judge as to what facts or circumstances would make life or death the appropriate punishment, Magatha found himself not simply puzzled by the difference in the sentences, but feeling a severe sense of injustice. Why is it, when he and Wilkinson had committed precisely the same crime, that they were given these sentences with such radically different consequences? Indeed, Magatha saw the imposition of different liability prices in the absence of authoritative sentencing standards produced either by the legislature or by the judge in instructions to the jury as violating the 14th Amendment to the United States Constitution. The 14th Amendment states that no state, in this case California, shall deprive any person of life, liberty, or property without due process of law. So in this particular case, Magathas was arguing that his life literally was being taken from him without due process of law. The phrase due process of law is not an easy one to translate, and many people believe that it simply refers to the procedures under which criminal cases are determined. So one gets due process of law when the procedures used to try one are fair and without any errors in them. Others think that the phrase due process of law connotes procedural due process, what I've just described, but that it also connotes fairness or justice, and that if an injustice is done to somebody, if they've lost their life, liberty, or property unjustly, then these people believe that the 14th Amendment protects them, individuals, from losing their life, liberty, or property unfairly or unjustly. This was the kind of claim that Magathas made. He did not argue that the law was misapplied in his particular case, and he did not argue that the trial was flawed. He argued that his 14th Amendment rights were violated because the sentence itself, without authoritative standards to guide the jury's discretion, was, as his attorneys put it, fundamentally lawless, by which they meant that there was no capital sentencing law in California until the jurors, in what the attorneys called their untrammeled discretion, created this law anew in every case. So the question before the floor is, does the 14th Amendment require that the information paradox be ameliorated by legislatively defined sentencing standards? This was Magathas' claim. He argued that if there were no sentencing standards, that the juries would be able to sentence arbitrarily, and if they sentenced arbitrarily, then people like Magathas would not know, before they decided to commit their crimes, what would happen to them after they had committed the crime. So we might infer that one implicit claim that Magathas is making is that if he knew before he committed these armed robberies that if there was a death and he was going to be convicted of first-degree felony murder and be sentenced to death, then he seems to suggest he might not have committed the crime. And therefore, the state of California has an obligation to him, before he decides whether to commit the crime or not, to tell him in more detail and with much, much more precision than was done in his actual case, what might happen to him after he committed his crime. This was the question before the Supreme Court of the United States, and it split rather sharply on that question. The majority opinion was written by Justice John Marshall Harlan. Indeed, it was from his opinion in this case that I drew my earlier quote about the infinite number of facts and facets in every different case. Harlan's argument, generally speaking, was that the attempt to make before the fact a priori sentencing standards that accurately predicted the moral costs of particular crimes that had not yet been committed was a futile exercise, that in fact it was not possible for legislatures to determine in any meaningful way before the fact which first-degree felony murderers should live and which first-degree felony murderers should die. For Justice Harlan, this was the job of juries. Juries, as I've said before, are in Harlan's and many, many other people's views, the voice of society in the legal process. They represent the moral cost bearers. They're drawn from the ranks of the moral cost bearers themselves, and they're the ones who set liability prices by reckoning as best they can what the moral costs that were imposed by this particular crime were, and therefore what the appropriate liability price might be that would internalize those moral costs. And so, Justice Harlan said, the 14th Amendment cannot require the impossible. If states attempted sentencing standards under these circumstances, Harlan suggested, it would invite jury nullification, which is a tactic by juries when they are faced with sentences that they do not wish to impose, they may simply declare the defendant innocent even though they believe the defendant guilty, so as to avoid imposing that high sentence. In terms of our example in the earlier lecture about the mandatory gun law, although a jury might be very comfortable sentencing our contract killer to a 1-year jail term under the mandatory sentencing law, it might be very uncomfortable about sending the young bullied teenager to the same prison for the same 1-year term for a similar offense. And so, to avoid sending that boy to the prison for a year, the jurors might simply decide, even though they believe him to be guilty of the crime, to simply acquit so that he is not faced with the jeopardy of the mandatory 1-year sentence. All of this, Justice Harlan suggests that the legislatures can't set sentencing standards before the fact and constrain juries in this way if they want their penalties to accurately reflect the moral costs that are imposed by crimes. This was the majority opinion. But in a very lengthy scholarly dissent, Justice William J. Brennan argued the contrary. States, he said, have an obligation to articulate their penal policy in authoritative law so that citizens can mold their behavior to the commands of the law. So, for Justice Brennan, California has an obligation to say before the fact what it is about a felony murder that would transform it into a capital crime, and what it is about a felony murder that would leave it as a crime punished by life imprisonment. States must tell their citizens what the penal policy of the state of California is. The legislature's feet must be put to the fire, and it must say clearly what is illegal and what isn't, and what the penalties are if the illegal acts are being committed. To impose liability prices, he argued, that are not at least signaling before the fact to potential offenders what the price of their crimes might be, for Justice Brennan, is the taking of life without due process of law. So Magathas was decided, and the holding was that the absence of authoritative sentencing standards did not violate Magathas' 14th Amendment rights. But just 1 year later, in another death penalty case called Furman versus Georgia, the result of the Magathas case was overruled sub silentio, which means that the ruling of Magathas was rendered inoperative thereafter, even though the case was not explicitly overruled in Furman versus Georgia, because Furman versus Georgia held that even though capital sentencing standards were not required by the 14th Amendment, they were required by the 8th Amendment, which prohibits the states from inflicting cruel and unusual punishments. And this decision requiring capital sentencing standards under the 8th Amendment was affirmed and refined in a series of 1976 death penalty cases, which held that statutory lists of aggravating or mitigating circumstances for juries to consider were required by legislatures. That is to say, Justice Brennan's dissent in Magathas was adopted by the majority in 1976, and since that time, states have not been able to inflict the death penalty on any defendant without first listing aggravating and mitigating circumstances of the crime, and then giving those standards to jurors or judges who then decide the appropriate punishment. At the same time, the court forbade mandatory capital sentences for the same reasons that we've adumbrated up until this point. Mandatory capital sentences simply do not discriminate between the various levels of moral cost sufficiently finely to allow them to pass constitutional muster. And as a result, mandatory sentences are unconstitutional. Let me close our discussion of criminal liability with a very interesting point. I've said earlier, several times and in several different ways, that efficiency and justice are not the same thing. That to say an allocation of property rights or goods is efficient is not the same as saying that that allocation of goods or property rights is just or fair. Despite this, the system of exchange, the system of tort liability, and the system of criminal liability are not completely independent of notions of justice. All three of them, I believe, express and try to enforce a particular moral precept or moral standard to determine when it is or is not appropriate to impose costs. And that standard, as we've seen, is reflected in the setting of competitive prices equal to the cost of producing the good which is being proposed for sale. It's that $1 price tag on the oranges that simultaneously measures the costs of producing that orange and informs the potential consumer as to what she will have to pay in order to impose those costs of production and to consume the orange. And from this comes a precept of justice, and that is, take only what you can pay for and pay in full for what you take, which, at the end of the day, is not a bad rule to live by.